We have major historic news from Rome. On July 26, the United Section of the Italian Supreme Court of Cassation, Sezioni Unite, issued landmark judgment number 125/2026. Here is the bottom line. The minor issue is officially dead before Italian judicial courts. The United Sections have confirmed that children born abroad in jus soli countries retain their Italian citizenship ab origine, which means since the beginning, under Article 7 of Law 555/1912, regardless of whether their parents naturalized during their minority. Before examining the core principle established by the Court, allow me a quick pause. I am Michele Vitale, attorney and founder of italyget.com. This content is brought to you by me. If you find this analysis helpful, please take a moment to like the video and subscribe to the channel. It really helps me produce more in-depth content like this. And if you would like to work with me on your citizenship case or for a consultation, you can contact me directly by clicking the link in the video description below this video. Now let's get right back to the ruling. Let's break down the technical core of the decision, because the Court's reasoning hinges on a fundamental distinction: dual citizenship ab origine versus derivative acquisition. For over a year, administrative interpretation under Consular Circular 43347/2024 attempted to apply Article 12, Paragraph 2 of Law 555/1912 to foreign-born dual citizens. Under Article 12, a minor child loses Italian citizenship if they acquire a foreign citizenship as a derivative consequence of their parents' voluntary naturalization. However, the United Section ruled that Article 12, Paragraph 2 applies exclusively to children who were born holding only Italian citizenship. If you were born in a jus solis jurisdiction, like the United States or Canada, you acquired foreign nationality at the exact moment of birth, simultaneously with your Italian citizenship Jure Sanguinis. When your parent naturalized years later, you did not acquire foreign nationality, you already held it. Therefore, Article 7 of Law 555/1912 protects your dual citizenship status for life. Now, many of you are asking, how does this ruling interact with Law 74, the so-called Tajani Decree? There is a direct legal conflict. When Parliament enacted Law 74/2025, Article 3 bis was specifically drafted with an explicit statutory clause that derogates from or overrides Article 7 of Law 555/1912 for foreign-born individuals. However, and this is vital, Law 74 is not retroactive. The United Sections confirmed that for all judicial actions pending before the entry into force of Law 74/2025, specifically claims filed before March 27, Law 74 does not apply. In all those pending proceedings, Article 7 remains fully operative, and applicants are completely protected under Judgment 125. From an abstract procedural perspective, let's examine how past consular rejections issued under the old administrative circular behave after this Supreme Court ruling. Under Italian administrative law, specifically Law 241/1990, the public administration possesses discretionary self-correction powers, known as autotutela. However, as the Council of State clarified in ruling 2564 of 2022, administrative bodies are generally not legally mandated to automatically reopen closed administrative files upon request. This brings us to the primary judicial pathway, petitioning the ordinary civil court, Tribunale Ordinario, in Italy. In Italian jurisprudence, an action for the formal declaration of citizenship Jure Sanguinis, the so-called azione di mero accertamento dello status civitatis, is completely imprescriptible. It is not subject to any statute or limitations or 60 days administrative deadline. In civil court, the judge does not merely review the consulate's decision. The judge independently ascertains your status under the Sezioni Unite 125 ruling and declares your citizenship from birth. If you want to read the unabridged, word-by-word English translation of the full 28-page ruling, as well as the original text and my full legal commentary, head over to italyget.com. The link is directly in the description below this video. One crucial final call-out. If your court case was filed after March 27, 2025, you must watch my previous video on Ordinanza number 147/2026 of the Italian Constitutional Court. That video details the Constitutional Court's official referral of Article 3bis of Law 74 to the Court of Justice of the European Union in Luxembourg. Click the video box right here on screen to watch it now. Click it now, I'll see you in that video. Thank you for watching, subscribe for further updates, and I'll see you in my next video. Ciao!